Thank you, Steven Donziger, for joining us on Objections. Before we go into your case, which is coming up soon, I want to establish a little bit of background for listeners who don't know that much about Chevron in Ecuador. This actually began when it was Texaco in Ecuador. Can you tell me the history of that and your client's case?
Sure, Adam. It's good to be here. Thank you for having me. So, in a nutshell, Texaco went into this Amazon region of Ecuador in the mid 1960s. They signed a deal with the then military government of Ecuador to drill in a 1,500 square mile area of rainforest that was home to 5 indigenous peoples. And over the next 15 years or so, they built hundreds of operational well sites, a very large area. And they created a system, engineered a system that had several flaws. The most fundamental of which was that it was designed to pollute. It basically took the drilling muds, which come out of the earth when you perforate a well, that have chemicals and heavy metals and very harmful substances that can, hurt the environment and cause cancer. They just dumped them into these pits they had gouged out of the jungle, about 1,000 of them, and they didn't line the pits, and they took pipes into the sides of the pits and ran off the contents into rivers and streams that the local communities relied on for their drinking water, their bathing, and their fishing. And in addition to that, they dumped literally billions of gallons of what's called water of separation, the scalding hot, carcinogenic water that you have to separate out from the oil when it comes out of the ground. The oil goes to market, the water needs to be disposed of. The normal way to dispose of it is to re-inject it deep into the ground, and they just built these industrial sized pipes and dumped it systematically, sometimes millions of gallons a day into the rivers and streams that, again, the local indigenous groups had relied on for their drinking water. So over time, in a kind of a relatively brief period of time, because the indigenous groups have lived in this area prosperously for millennia, just a few years, they were living in an environment that, according to our experts, suggest that it was completely poisoned. I mean, they were basically being exposed multiple times a day to cancer-causing toxins, both in the water they drank and the air they breathed and in the food they were eating. And over time, the health impacts were devastating. So to kind of wrap all that up, Texaco operated from 1964 to 1992 with this very, this type of flawed system. I went down there a year after they had left in 1993 for the first time with a group of lawyers and scientists to investigate what we had heard was a terrible oil contamination. And after we visited it and confirmed that it was really bad and the people were desperate and many were dying and they needed help, we decided to file a lawsuit in November of 93 here in the United States in Manhattan, which was the site of Texaco's headquarters. And here I am 28 years later, still working to some degree on the same lawsuit.
So you filed the case in the Southern District of New York in 1993. It's taken many turns since then, to put it mildly. Just to be clear, so though Texaco and then Chevron, they never disputed that the Ecuadorian Amazon was polluted. What they disputed some of the residual effects. They disputed who was responsible for it. Nobody disputes that there remain a number of oil pools that anyone visiting the Ecuadorian Amazon can see today, correct?
That's absolutely correct. I mean, to put it another way, Chevron does not dispute that it dumped all of this toxic waste into the Amazon. Their legal defenses rely heavily on the idea that they're not the responsible party at this point. It's Ecuador's government that bears the responsibility. We disagree with that. So do the courts of Ecuador that ruled on the case, but that's always been their position. And they also claim that to some degree, the damage caused isn't harming anyone to such a degree that you need to clean it up, which, by the way, is a classic polluter's defense. You see this a lot in US courts where, they acknowledge, a mining company will acknowledge, tailings and there's massive pollution, but they'll say, well, there's no reason to spend money to clean it up. It's not hurting anyone. Just let it sit there and it'll biodegrade over, thousands of years. So, that's like a classic, I think, very weak defense. I think the idea that it's Ecuador's responsibility now is also very weak. That's been rejected by multiple courts in Ecuador and around the world. They're on the hook for now a $9.5 billion liability plus interest. It's sizable. I mean, it's frankly modest in my view compared to the magnitude of the damage. It's modest compared to BP's liability for the Deepwater Horizon accident that took place in the Gulf of Mexico in 2010. But it's still a big number, and they don't want to pay it, and they're pulling out all the stops not to pay it, and that revolves heavily around attacking me personally.
So let's talk about what happened since the lawsuit was originally filed in New York in 1993. Somewhere in the mid 90s, the Texaco enters into this agreement with the Ecuadorian government, which is part of their defense, where they're claiming they're not liable. And then, how you mentioned an Ecuadorian court ruled. Tell the listeners how the case got to Ecuador to begin with.
Okay, so our clients in the early 90s wanted the case in the US. They didn't trust their own country's court system. I mean, Texaco had been polluting for many, many years, and there wasn't a single judgment in tort for even $1 against Texaco that entire time. I mean, the court system was very small, and the indigenous peoples I think not only did they not understand the court system, they didn't know how to find lawyers or get money to pay lawyers. I mean, these are people who live with no money for the most part, live off the forest. And there was just a complete disconnect, between the people harmed and the remedy or the system to provide a remedy, meaning the court system. I mean, it was like a cultural disconnect. So when we got down there and explained, well, you actually have a place to go to sue, they wanted to do the lawsuit, but they didn't want it there because they didn't trust their own institutions or their own government. So we did it here for various reasons in New York, and also, understand that Texaco's headquarters were in New York at that time, and the decisions made in Texaco to build this system to pollute in Ecuador were made in New York. So it all made sense to us to do the case in New York. Now, that entire decade of the 90s, Texaco, still Texaco then, because remember, Chevron bought Texaco in 2001. So during the entire decade of the 90s, Texaco hired Griffin Bell. People might remember him from King and Spalding, and he was the Attorney General of the United States under Jimmy Carter. And he was the man hired by Exxon to defend Exxon after the Valdez spill. So sort of Chevron turned to him and his law firm to help them through this situation. And the entire decade of the 90s, I mean, literally 10 years, we were fighting over whether the people of Ecuador could actually enter the courthouse door of the United States. And that went up and down to the Second Circuit twice. There were all sorts of decisions, all sorts of litigation, discovery around various issues. And ultimately, Texaco, by then it was Chevron, won that skirmish and was able to move the case to Ecuador on the condition that it agreed to jurisdiction in Ecuador. That's a very important point. And even though it took 10 years, that was somewhat of a legal victory for our side. They had to agree to accept the jurisdiction of Ecuador's courts, and they promised to pay any adverse judgment should one come about in Ecuador, subject to various enforcement defenses. So, that was an enormous victory, I think, for the indigenous peoples of Ecuador to get a case to happen. Even though it wasn't their preferred forum, it was still going to happen, and they were not going to be able to challenge jurisdiction. So the case ended up happening in Ecuador with Chevron subject to jurisdiction, largely as a function of the 10 years of legal battles we had in the United States in the 1990s.
So the case is moved to Ecuador at Chevron's request. Just before you win a multi-billion-dollar ruling there, the counteroffensive begins.
Yes.
Can you talk to me about what happened? Chevron brought the case back to New York.
Well, this is how I see it. They didn't bring the case back to New York. They started a new case in New York to attack the case in Ecuador that we had won and they had lost. So, as it became clear, and the evidence that we were producing, and even they were producing over an 8-year, just a super exhausting, grueling 8-year trial that involved field inspections of contaminated sites, 105 expert reports, 64,000 chemical sampling results from both parties. I mean, this was a heavily litigated case with a lot of scientific evidence. And it became very clear as we were getting toward the end that they were going to lose if the judge was able to rule on the evidence. And that was my view. I think that was their view. So they started to do things to set themselves up to collaterally attack the judgment after it came down, attack it in the United States or other countries where the Ecuadorians might take it to enforce it against Chevron's assets. It became very clear Chevron had no intention of paying the judgment, even before the case ended. And they as much said so. They said things like, we're going to, fight this until hell freezes over, then fight it out on the ice. They said, one of their spokespeople said, they threaten the indigenous peoples with what they call a lifetime of litigation unless they drop the case. So they were gearing up for a long battle. They had made a decision they were not going to pay this judgment. And as I look back on it, I think I was maybe a little naive in thinking that they would pay the judgment or at least try to settle the case at that point. So they then, and this was crazy, but even before the judgment came down, 2 weeks before, they filed a civil racketeering case against me, against all 47 named plaintiffs in Ecuador, against community leaders, against our scientific consultants, et cetera, a bunch of people. Here in New York, in the very court, this is irony of ironies, right? In the very court where the Ecuadorians originally brought the case, where Chevron never wanted to try the case, and the very court that Chevron, moved the case out of. Chevron came back to that court to attack us, and this is my home, New York. Lived here for 25 years now. And they were able to establish jurisdiction over me personally, as well as some of the Ecuadorians here. And they began their counteroffensive. It's been brutal.
And you mentioned it was a civil racketeering suit, a statute used originally to combat organized crime. They were leveling very serious offenses at you, and this was civil litigation. You didn't have a jury trial. You wanted a jury trial at the time, and there's a ruling against you, 400 pages, accusing you. I mean, can you run down the list of some of the things you were found? The judge said you committed money laundering. The judge said that you had cooked scientific reports. These were very serious claims. You were never prosecuted for any of that, correct?
That's right. I mean, there were allegations by Chevron in the civil case that I committed felony criminal offenses in Ecuador. Let me be clear. But the trial was not a criminal trial. I never had the due process given to criminal defendants. I never had a jury. I only had one judge who made it very clear his animus against me, his dislike of me was palpable from the very beginning. Luke Kaplan, might as well say his name. Judge Kaplan is a former tobacco industry defense lawyer who, is very, in my view, pro-corporate. And I think I don't believe he was judging the case, in a way judges are supposed to judge cases, which is neutrally. I think he had an agenda and really wanted to use me and use the case to make a point, which is that I don't like the idea of human rights lawyers and environmental justice lawyers who just plain plaintiffs lawyers, going down and riling up these people in these other countries against US companies and winning big judgments in those courts. And I think he didn't like that. I think he found it distasteful, and I think he found any way he could to help them go after me. Now, about the charges, these are serious charges, to be clear. I reject them. I completely reject them. I did not do anything wrong, in my view, either ethically or legally. And what's bizarre about this is his findings have been either ignored or rejected by multiple appellate courts in Ecuador and in Canada, which ruled on this case for enforcement purposes. We have, the Supreme Courts of both Ecuador and Canada have validated the judgment for enforcement purposes. And that happened after Kaplan found, that I committed these criminal allegations without a jury. Criminal offenses without a jury. The bottom line is this was Chevron's plan. They tried to get me criminally prosecuted under RICO, under criminal RICO. The Wall Street Journal just reported that the other day, but way back in 2010. When that didn't work, they went after me with civil RICO, which they could control. They steered it to Judge Kaplan. And by the way, I'm the only defendant in a civil RICO case in the history of our country who never had a jury. I'm the only individual who never had a jury. They sued me for treble damages on the original judgment. $60 billion, billion with a B. I was facing, I think, the largest personal liability in US history. And I live in a 2-bedroom apartment with my wife and son. It just got into crazy land really fast. But the important point is the courts that really matter, in my view, that looked at all the evidence. Judge Kaplan, for example, refused to look at any of the environmental evidence that the Ecuador courts relied on to find Chevron liable. He refused to look at our evidence that Chevron had committed fraud in Ecuador and done all sorts of terrible things down there that were inappropriate, including trying to entrap a judge in a bribery scandal. So he excluded all that evidence, focused on me, let Chevron pay a witness, Alberto Guerra, $2 million plus to come in, and he testified he was in a meeting where I bribed a judge. He later admitted lying, not about that, but lots of other important things. In my view, he has no credibility. And there's no evidence I did that other than the words out of his mouth, and he was paid by Chevron. So in my view, honestly, I was framed in this court, and it kills me that it happened. But I have to live with this judgment because it exists as a matter of fact in US courts, even though there are completely contrary judgments that I think are much more reliable from other countries that have ruled otherwise.
So you mentioned Judge Alberto Guerra and the bribery allegations. It's another example where in Judge Kaplan's ruling, he explicitly said that you committed criminal offenses. That was his words. You have never been prosecuted or charged or accused by a U.S. Attorney's Office about it. Part of the reason that we're talking today is your trial is about to begin, another criminal trial. On none of the things that Judge Kaplan accused you of, and you're not being prosecuted by the U.S. Attorney's Office. Can you tell me how this case began?
Yeah, I mean, everything's so complex. Look, writ large, I'm being targeted by Chevron and dozens of law firms that they pay. Okay, I am probably the target of the most well-financed corporate attack campaign through the law in our country's history. I mean, what's happening to me makes what happened to Ralph Nader with the GM scandal seem like very small potatoes, okay? And I've been dealing with this for 10 years now. It's a demonized Donziger campaign. It's in their emails. Specifically, what's happening to me now, and the reason I'm going on criminal trial next week, is because Chevron got Judge Kaplan after the RICO trial, that jury millions of dollars of cost orders on me. And under the theory, I couldn't pay the money, I didn't have it. So, whatever money I had, they took out of my bank accounts. They basically bankrupted me. I'm living off donations and my wife's generosity. She works. So they had a theory that I had hidden away money, and they wanted to get my computer and cell phone to examine them. And when Judge Kaplan asked me to do that, and I'd already represented, I didn't have any more money. I said, I can't do that. I have ethical obligations to my clients. There's privileged information on my computers and cell phones, and I can't wholesale turn this over to your specialist who's going to turn it over to Chevron. So I asked Judge Kaplan ethically, I was principled, I believe, and I said, can you please hold me in voluntary civil contempt so I can get a direct appeal of your lawful that I believe is unconstitutional or not correct? And he did hold me in civil contempt. He fined me. I then appealed. And, a few days or about a month later, I think it was, he charged me with criminal contempt of court for not complying with an order that was under appeal at the time he charged me criminally. And we've done a lot of research. We have never found a single case in the United States where a lawyer who did what I did, which was to ask to go into civil contempt to get a direct appeal, was later charged criminally for doing so. We think the whole case is baseless, but the bizarre thing is when Judge Kaplan one of the bizarre things is when he took these charges to the U.S. attorney to prosecute me, which he was legally obligated to do. I mean, judges don't prosecute in the United States. Separation of powers is such that the executive branch prosecutes, the U.S. attorney's office, except in rare circumstances where like a judge is like, oh, he's not, this lawyer's not complying with an order, I'm going to prosecute him. But even in those rare circumstances, you have to take it to the U.S. attorney to do the prosecution. And when Judge Kaplan took it to the SDNY here in New York, Jeffrey Berman was the U.S. attorney, they rejected They declined to prosecute for whatever reason. And I think that's very telling because it's the second time Chevron or Judge Kaplan has taken facts related to what they claim is my criminal behavior to the U.S. attorney, and the U.S. attorney has declined to prosecute. So Kaplan's next move was to appoint a private law firm to prosecute me in the name of the people. And this is where it really turns, to me, kind of into crazy land again. The law firm he appointed, Stewart and Kissel, I didn't know it at the time he appointed them, but I found this out 7 months later. They had Chevron as a client as recently as 2018, that is the year before Kaplan charged me. And they also have extensive financial ties to big oil and gas companies. They're basically an oil industry law firm. And it just blows my mind that of all the, ex-federal prosecutors in New York that Judge Kaplan could have appointed, he appointed like the one law firm that has a financial tie to Chevron to prosecute me. Now, at that point, when I showed up to face these charges that I was just shocked by, the very first day, the prosecutor, Rita Glavin, from this Chevron law firm, asked for me to be detained in my home because she claimed I was a flight risk to Ecuador, which, again, is preposterous. I mean, and I've been here ever since. I mean, I've been here now for 638 days, and it's a misdemeanor case, meaning the maximum sentence is 180 days in prison. The longest sentence in this district in New York ever imposed on a lawyer convicted of criminal contempt of court is 90 days of home confinement. And that was given to Bruce Cutler in 1994. So what's happening to me, Adam, is very onerous, it's punitive, and it's highly irregular. And I don't think it would be happening if I were to be prosecuted by the DOJ. I think it's happening because this is Chevron's plan to wrest control of the prosecutorial machinery of the people and direct it against its main critic. And the final thing I just want to say about Stewart and Kissel and the Chevron law firm that's prosecuting me is they are being subsidized by taxpayers for the prosecution. 3 lawyers are billing taxpayers $300 an hour each for their work to basically put me in jail. And so far, we only have about half their bills. They've billed at least $500,000 to prosecute me. And I think, as you pointed out in one of your stories a while back, the maximum amount a defense lawyer gets paid under statute to defend a misdemeanor is like something like $3,500. And they've already spent $500,000. So it's really not right. And to me, it's the first corporate criminal prosecution in our country's history. And it explains why I'm locked up in my own home now for almost 2 years without trial on a misdemeanor charge.
I want to pivot to something that just happened very recently. You got the support of elected officials, including Representative Jamie Raskin, who was the lead impeachment prosecutor. You had Congresswoman Alexandria Ocasio-Cortez and a number of other people. What's interesting about what they did, they wrote a request for the DOJ to intervene in your case. So just to kind of go back, unpack the meaning of this.
Crazy.
The fact that they are asking the prosecuting arm of the government to intervene in a case where you're charged by a judge for criminal contempt of court, when the same judge has accused you of other very serious conduct.
Well, we kind of laugh about this in our legal team, but I'm probably the only lawyer in America ever to really be begging to be prosecuted by the DOJ criminally. And that's my posture right now. Because to be prosecuted by a private Chevron law firm is a non-starter. I mean, they're completely trying to destroy my life by locking me up. They're not negotiating in good faith or resolution. I mean, I could have resolved this thing in a month had I had a professional prosecutor, and we would have figured it out. But that's not the point of the exercise to Chevron. Chevron wants to silence my advocacy, keep me locked up so I can't help enforce the judgment, and use me as a weapon to intimidate other human rights lawyers so they don't do this work. And those objectives are only accomplished if they control the case and they keep me locked up for as long as possible, even though it's a misdemeanor, which means I don't get a jury yet again. And, so if I were to get a DOJ rejected this, I'm assuming step in and fix this, what is a flagrant conflict of interest for me to be prosecuted by a private law firm with a financial interest in the outcome. If they were to step in, I'm assuming we could resolve this very quickly and I could get my freedom back. So I pray every day the DOJ responds to the letter from the congresspersons, from Jamie Raskin, AOC, and Jim McGovern, Cori Bush, Jamal Bowman, Rashida Tlaib also was on the letter. By the way, there's been 68 Nobel laureates just sent a similar letter this week to Merrick Garland, asking him to do the same. And several human rights groups, including Amnesty International, also have written a separate letter. So there's 3 letters that he has on his desk. Look, he probably has a lot of other things he's dealing with besides the case of Steve Donziger, but there are 3 letters from some very prominent people on his desk. And, our hope is that he will review this case, stop the trial, which is scheduled to start Monday, and really review the case and ultimately decide to take it back from the Chevron prosecutor and handle it through the DOJ. That's our goal. By the way, even if it doesn't happen, it can happen anytime during the trial or even after the trial. The DOJ can decide to take the case back and, really fix a problem of where one person, and this is Judge Kaplan, is really serving in the same case as my grand jury, as my prosecutor, as my judge, and as my sentencer. And like separation of powers in our country, you don't see that. That's China. That's maybe Saudi Arabia. It's not the United States. In the United States, the executive branch prosecutes, judges judge. Judges don't prosecute. He can charge me, but he's got to get out of the case at that point and let professionals prosecute so it doesn't get tainted by the emotion of him, which it is. He's still in the case. He's never recused himself. And even though he appointed a close colleague, Loretta Preska, who, by the way, is a leader of the Federalist Society, which is funded by Chevron, to preside over my criminal contempt case, he's working with her behind the scenes. They communicate constantly. He admits he has not recused himself. And I believe he's driving the case from the shadows. So, it's a bad look. My judge is not behaving, in my opinion, consistent with the Constitution. Judge Kaplan, my charging judge, the presiding judge, has financial ties to Chevron through her advocacy. And my prosecutor has financial ties to Chevron and is not disinterested as required by law. Prosecutors have to be disinterested. They cannot have a financial outcome in a case they're prosecuting. And on all of those counts, I believe DOJ policy and various legal precedents are being violated by these 3 people. And it's at my expense because I'm hurting.
Thank you for making the time, Steven. And let's keep in touch as the trial goes on.
Thank you so much, Adam. Appreciate it.